Welcome to LexIcon, your visual guide to public international law. During our last lecture, we were speaking about states as original and primary subjects of international law, but it will also be useful to define what is a state. Therefore, today we will speak about how are states born. In other words, we will speak about statehood and its elements. Statehood is the condition of being a state. And a couple of important points have to be made here. First, there is no universal definition of a state. A legal scholar and a political scientist will view and interpret and define the notion of state differently. And second, state is an artificial entity. State is not just the territory or just the government, it is the whole system. To give you some context, in 1890, the Pan American Union was formed to promote cooperation among the Latin American countries and the United States of America. In that period, until 1928, 6 international conferences of American states were held. And in December 1933, the 7th International Conference of American States was held in Uruguay. This is precisely when the Montevideo Convention on the Rights and Duties of States was adopted. It is also the first document where the elements of statehood are listed in a written form. So let's take a look at Article 1 of the Montevideo Convention. It provides that the state as a person of international law should possess the following qualifications: A permanent population, B, a defined territory, C, government, and D, capacity to enter into relations with the other states. Let's consider them one by one. Permanent population. A very well-known legal scholar and practitioner, James Crawford, wrote that if states are territorial entities, they are also aggregates of individuals. In other words, there can be no state without population. But then there is no minimum requirement. There are states that are very densely populated, and then there are states with less population. This does not change anything for the purposes of determination of statehood. Second, defined territory. Well, this is quite evident. It is hard to imagine a state without the land, without the territory, because states are primarily territorial entities. But again, there is no minimum requirement. Crawford wrote that sovereignty comes in all shapes and sizes. Some important notes have to be made about the territory. Territory of state should not or should no longer belong to any other sovereign state. So what you see on the right is incorrect. This will be the correct version. The territory should belong to that state. And here an obvious question would appear: what about border disputes? Here the rule is that the state should possess control over some core territory. Core territory is also not defined in geographical terms, but the presence of a border conflict or the absence of a clearly defined, clearly delimited boundary is not an obstacle to statehood. And here, the requirement of core territory also makes the idea of cyberstate quite problematic from the point of view of traditional international law. But we move further to government. Government here is not just some formal structure, but rather a government that is capable of exercising effective control over the territory and the population. Government is in fact the central element of statehood for a number of reasons. First, other elements are dependent on its existence. We speak about the territory that is governed and the population that is governed. Second, the existence of government is important as it ensures internal functioning of the state. And finally, states operate externally also through their governments. So in order to be a part of the international legal system, a state should have a government. What about the form of government? Is it prescribed or not? The definition doesn't prescribe a particular form of government, because for determination of statehood, the type of political regime is not a relevant factor. So we may have a liberal democracy, but we may also have an autocratic state, and a non-democratic or non-liberal state would still be a state. But here, state shall not be confused with the government. State as a whole is one thing, but then government is a part of it. That's why the change of the government is not the same thing as the change of statehood. We may have one state that does not cease to exist, it in fact continues to exist, but there the change of government occurs within that state. Here an interesting question regarding occupation may appear. What happens to statehood? In case of belligerent occupation, an occupation that is taking place during a military conflict, the continuity of the state is not affected until the conflict is settled. And military occupation is sometimes linked to a situation of government in exile. Government in exile is the government that, for a certain time, does not have the effective control over the territory of the state. In other words, it is the government that resides elsewhere, not in the territory of that state. But its powers continue to exist, although they cannot be exercised. It is in a way a certain legal fiction. Finally, we come to the capacity to enter into relations with other states. When you look at it, you do not really understand what precisely is meant. And this is a characteristic of this requirement. There is no precise legal scope of this requirement. Also, the capacity to enter into international relations would rather be a consequence of statehood rather than a prerequisite for statehood. This requirement was quite useful at the time of the adoption of the Montevideo Convention in the 1930s, when there were the colonizers and the colonized, but today this requirement is considered somewhat less relevant. Many scholars also suggest other factors, such as independence, sovereignty, permanence, and others, but let us concentrate on one particular requirement: recognition. Should a new state be recognized by other states on the international arena to qualify as a real state? This will be the topic for our next lecture. But let's take a final look at Article 1 of the Montevideo Convention. We can conclude that the first two criteria are more formal, whereas the third and the fourth are more substantial. And here a final note. Statehood is not just a factual situation. It is a factual situation that is established and interpreted through law. That's why the Montevideo Convention should not be the end point. It should rather be a starting point for academic debate on statehood. That's it for today. I hope this video is useful. If you have any questions, leave them down below, and I see you very soon.